I'm Kevin Carnes. As your lead clerk and comptroller, I'm committed to ensuring you have helpful and easy to access service from the clerk's office. This how-to seminar is designed to assist you in navigating your court services and Lee County's official records. You can attend these sessions in person or view them online at leeclerk.org. I hope this convenient service enhances your customer experience with my office.
Hello, and welcome to your Lee County Clerk of Court and Comptroller's Office How-To Seminar on Guardianship. My name is Yesenia Williams. I am the Community Relations Manager with your Lee County Clerk of Court and Comptroller's Office, and I'm delighted to go over this information with you today. A brief overview of our presentation. We'll talk a little bit about guardianship and guardian advocacy, as well as the difference between both. We'll go over the different types of guardianship cases, the guardianship process from filing the documents with the courts to the actual hearing being held, some court and form requirements, as well as some available resources for you. I do want to preface this presentation by mentioning that the clerk's office is a ministerial office, which means we cannot provide you with any legal advice. So we're only going to go over this process from a procedural standpoint. If you do need to seek legal advice, we do encourage you to contact an attorney. So what is a guardianship case? Guardianship is governed by Florida Statute 744. I do encourage you to visit that statute and read up on it, but it is a legal proceeding that is designed to protect and exercise the legal rights of individuals whose functional limitations prevent them from being able to make their own decisions. Individuals may need a guardian for the following reasons, including dementia, Alzheimer's disease, chronic conditions that can cause functional limitations, or a developmental disability. An individual must be adjudicated by the court as incapacitated before a guardianship can be established. The only exception to what I just mentioned is guardian advocacy, which is governed by a different Florida statute, and I will go over that a little later in the presentation. Guardianships may be established for a variety of reasons. This can include someone who is declared incompetent or incapacitated, or a minor who has inherited money or real property over $15,000, is a recipient of a court settlement over $15,000, or is living with someone other than a parent who will need to make decisions about schooling and health care. It is imperative that every guardian become familiar with the powers and duties of being a guardian reflected in the Florida statutes 744.361. One specific function of a guardian is to file initial and annual reports. These are outlined in the Florida statutes referenced here. So it is important that the guardian becomes familiar with these powers, including the duties, including filing these initial and annual reports. Guardian advocate. So this is different from guardianship. As I mentioned, it is governed by a different statute. This is statute 393. Parents no longer have the legal authority to make decisions for their children after they turn 18 years of age. So guardian advocacy is a process for family members, caregivers, or friends of individuals with a developmental disability to obtain the legal authority to act on their behalf once they've turned 18 years of age. This is accomplished without having to declare the person with a developmental disability incapacitated. So again, this is for individuals who have a developmental disability, and they must have been diagnosed with this developmental disability before the age of 18. The individual must be able to maintain one of their rights. This can include their social rights. And counsel is not required to file for guardian advocacy. Somebody can file for this case type without having to hire an attorney. Who can and cannot be a guardian? Any competent adult who is a resident of Florida can be a guardian, or any competent adult who is not a resident of Florida but is directly related to the ward can also be a guardian. Individuals who cannot be guardians include anyone who has been convicted of a felony, anyone who has been determined to have committed abuse, abandonment, or neglect against a child or elderly adult, or any person unable to perform their duties due to illness or incapacity themselves. There are a variety of different types of guardianship cases, and we will go over each one of these individually. Guardianship of the person. There is guardianship of the property. There's also guardianship of the person and or of the property, those two combined. Then there's guardian advocate of person and or property, and guardianship of minor property. So the first one we're going to go over is guardianship of the person. So guardianship of the person allows the guardian to exercise personal rights that have been removed from the ward. And these include applying for government benefits, suing and defending lawsuits, determining residence, consent to medical or mental health treatment, or decisions regarding the ward's social environment. Guardianship of the property gives the guardian rights over the ward's financial matters, and this includes receiving assets, paying reasonable living expenses, paying taxes and assessments, making repairs to the ward's home, or selling and or purchasing property. And as I mentioned, these two can be combined, so it would be guardianship of the person and or of the property. This brings us to guardianship of minor property. So again, if there are minors who receive an excess of $15,000 per statute, they must have a guardian to ensure the assets until they reach the age of maturity. So guardianship of minor property will give the guardian rights over their financial matters, and this includes receiving assets, paying reasonable living expenses, paying taxes and assessments, making repairs to the ward's home, or selling and or purchasing property. The most common types of guardianship cases that we see include guardian advocate of person and or property, plenary and or limited guardianship of person and or property, or minor guardianship. And we will go over these. First, guardian advocate of person and or property. So again, this individual must have been diagnosed with a developmental disability prior to the age of 18. They must be able to keep one of their personal rights as defined by statute. It only requires an attorney or counsel if the case includes property rights. We do have the forms and a guide available on our website that gives you the step-by-step process on filing for guardian advocacy. Once you're ready to file for that case, there is a filing fee associated with it. It is $235 at this time. Plenary and or limited guardianship of a person and or property is the next most common case type. Plenary just means complete guardianship of a person and or property, and then limited means just that, limited guardianship of a person and or property. For this kind of case, counsel is required, so you will need to seek the assistance of an attorney. You can either contact Florida Rural Legal Services for legal assistance, or the Florida Bar to research attorneys that can assist with this kind of case. In order to file for this kind of case, you must also file what's called an incapacity case to determine the person incapacitated in mental health court, and we'll go over what that looks like. The filing fee is $235 for the person only, or if you're seeking guardianship of the person and the property, it is $400, or $400 for property alone. Minor guardianship refers typically to only property rights. And then again, this is because the minor has money or real property over $15,000. Counsel, again, is required for this kind of case. So you would, again, need to do your own legal research to seek the assistance of counsel. The filing fee is the same as the one before, $235 for the person only, or $400 for the person and property. So the guardianship process has a variety of steps. The first thing that needs to be done is incapacity needs to be determined. So you would have to file a petition to determine incapacity. From there, you'd file a petition to appoint a guardian, and at that point, a hearing would be scheduled and held. So once a petition to determine incapacity is filed, what this is going to do is this petition is going to ask the court to find that the alleged incapacitated person, or the AIP, is indeed incapacitated. Once a case is opened, a mental health case will also be opened and assigned, and this will go in tandem with the guardianship case. And any competent adult may file a petition to determine incapacity. Once the petition is filed, the clerk will go ahead and prepare what's called an order appointing an attorney to represent the alleged incapacitated person. The clerk will also appoint an exam committee of 3 professionals to examine the alleged incapacitated person. These exam members must file their report of their findings with the court within 15 days of being appointed. The next petition that needs to be filed is a petition to appoint a guardian. What this petition is going to do is it's going to ask the court to appoint a guardian over the alleged incapacitated person. This petition may include the rights of the person and/or property in whole or in part. At this point, a guardianship case is opened and a guardianship case number is assigned. And again, this will go in tandem with the mental health case for incapacitated, to find the person incapacitated. The clerk will prepare an order appointing an attorney to represent the alleged incapacitated person. Once these petitions are filed and processed, a hearing will be scheduled by the clerk's office, and it will be scheduled within 6 weeks of filing the petition for guardianship. So at this hearing, the court will review the exam committee reports that were submitted. If the court does indeed determine incapacity, the court will need to ascertain if there are lesser restrictive alternatives to guardianship available, and these can include, for instance, a power of attorney. If there are no lesser restrictive alternatives available, the court will appoint a guardian over the ward. The guardian advocate process is slightly different. So the first thing that the person will need to do is file a petition to appoint guardian advocates, and from there a hearing is scheduled and held. So there is no need to determine anybody incapacitated before filing the petition to appoint in this particular process. So filing that petition, what that's going to do is it's going to ask the court to appoint a guardian advocate. This petition may include the rights of the person and/or property in whole or in part. The ward must be able to maintain at least one of their personal rights when filing for guardian advocacy. And any competent adult may file this kind of case. So once the clerk processes this petition, they will prepare an order appointing an attorney to represent the person with the developmental disability. We will not appoint an exam committee to examine the person with a developmental disability in this particular case. From there, a hearing is scheduled and held. The hearing will be scheduled within 4 to 6 weeks of filing that petition to appoint a guardian advocate. At the hearing itself, the court will make a determination as to whether or not the developmental disability does indeed exist. And this is based off of the testimony and/or medical records that have been filed by the petitioner. At that point, the court will also appoint a guardian advocate if indeed the person is found to have a developmental disability. This brings us to guardianship of a minor, and this does not refer to custody. Custody is a completely separate process that is done through family court. But with guardianship of a minor, you will need to file a petition to appoint a guardian, and a hearing is held. This petition will ask the court to appoint a guardian over the minor. The petition is geared towards the rights of the minor's property. Generally, this is what we see. It may include the rights to the person as well, but it's mostly geared towards the rights of the minor's property. The clerk's office will not appoint an attorney for this particular case type. And when it comes to the hearing itself, these hearings are scheduled at the discretion of the judge. The clerk's office will not schedule the hearing, so it is up to the petitioner to contact the judge's office of the judge who's assigned to the case to have a hearing scheduled. This brings us to some court requirements, and these can be fairly complex, so I do encourage you to do some additional research regarding these requirements based on the statutes that were mentioned in the beginning of the presentation regarding the duties of being a guardian. But once guardianship is established, the courts will require regular reporting. This includes an initial guardianship plan, inventory, and an annual guardianship plan. So again, I encourage you to read the duties of being a guardian, and that include these regular reporting requirements. We do have forms available on our website to file for guardianship. They're also available on the Supreme Court's website. Some of the forms we have available on our website include a petition to appoint guardian of a person, the application for appointment of a guardian, and the oath and designation of resident agent. We have a variety of information available on our website as well. If you visit us at www.leeclerk.org, under departments, you can click on guardianship as seen on the left side of the screen here. That'll bring you to our guardianship case, where you can access all of the various statutes, as well as some administrative office of the court's policies and procedures regarding guardianship, the guardian advocate information and how-to guide that I mentioned earlier in the presentation, and some FAQs as well. Some resources available to you include, again, our website that I just went over, our guardianship email address. You can reach our guardianship team at guardianship@leeclerk.org with any specific questions that you may have regarding guardianship or guardian advocacy. They will return your email within 24 to 48 business hours, so it's pretty quick turnaround time for any questions you may have. I encourage you to email the team there. There is some guardianship education courses. The guardian will be required to complete an 8-hour family guardianship course. This course is not offered through the clerk's office, but we do have some resources here available to you that you may access in order to take this course. And that brings us to the end of our presentation. Thank you so much for watching. I encourage you to connect with us by visiting our website using this QR code and following us on our social media platforms. Also encourage you to subscribe to our newsletter to be informed of all the latest and greatest going on with our office. If you have any specific questions, suggestions, or comments, feel free to email me directly at ywilliams@leeclerk.org, or you may call me at 239-533-2763. Thank you.